ownership attorney has entered the chat. According to the claim, Noah Springer put money into a company called Pickle Pro Labs, we'll just say PPL, and took a 25% stake. His partner was Jill Zarin from the Real Housewives of New York. Their company developed a machine that tests pickleball paddles and allegedly using Noah's money and work. Noah says that Jill and her boyfriend froze him out. They ran personal expenses through the company, paid themselves, but not him, and then opened a brand new company called CNG and started selling the machine through that new company instead. So he sued on behalf of himself and the business for breach of fiduciary duty, for conversion, which is just a legal word for treating the company's property like it's your own. And he filed a few other claims as well. Well, Jill fired back with a motion to dismiss. And here is a twist. Her motion barely argues about what she did or didn't do. It attacks how he filed and what he signed. So here are 3 lessons from this case that you can learn from legally. Lesson number 1. PPL is a Delaware company, meaning that it was formed in Delaware. And the operating agreement that Noah signed says that Delaware law governs it. But he sued under Florida law anyway, where the company is actually operating. Jill's motion to dismiss argues not only does the operating agreement say where and how the disputes get resolved, she points out that issues that touch on the company's internal affairs are governed by Delaware law under something called the Internal Affairs Doctrine. Here is what every owner needs to understand. You can generally pick the state where you operate to be the proper jurisdiction and choice of law in your operating agreement, but that choice has limits. It will usually apply to contract disputes, but it cannot replace the legal requirement mandating that the state where the company was formed to govern the company internal affairs. These are matters that's particular to relationships among the company, its officers, directors, managers, and owners. Lesson number 2, Noah did not sue, like we said, only for himself. He sued on behalf of the company, which the law calls this type of suit a derivative action. And that kind of case comes with a gate that you have to pass through first. Under Delaware law, in Florida too, you generally must first formally demand that the managers fix the problem or plead specific facts in your complaint showing why demanding would be pointless. Jill's motion to dismiss points out that Noah's complaint showed neither of these things. It said only that all conditions have been met, which is a conclusion and not a fact. The right to sue on behalf of your company is a process, and skipping the first step can sink the whole case, no matter how strong the underlying wrong is. Don't throw your right away by doing it wrong. And finally, lesson number 3, Noah complaint says that he invested $500,000, but the complaint submission of the Schedule A of the operating agreement that he signed lists his contribution as $1. And when the exhibit attached to the case contradicts the complaint, the document controls. He also said that the machine that they developed belonged to the company. Well, the complaint never pleads a single hard fact showing that the company owns the machine. There's no patent, there's no trademark, there's not even a written assignment, just the claim that the company built it. So Jill's motion to dismiss points out all of these things. And the takeaway is that if you are a creator, if you are a partner, if you are an owner, saying that you own something, that you invested in something, that you are owed something, none of that is the same as having a signed document that actually proves it. Although the judge has not ruled on the motion to dismiss, there are hard lessons that can be learned from it. Not understanding state law, missing steps in a process, and having a signed document that contradicts any argument that you may raise, all of this can cost you more than you bargained for. This is why I'm the ownership attorney.